Good evening, everyone. We're going to get started. Welcome to our second installment of our MS&J lecture series. The lecture series is something we started this year. It's a 1 hour examination of a topic. The last one Josh and I did regarding new member orientation to the medical society. And if you're interested in any of the topics that we do, these are going to be recorded and then posted to our website so people can review them if they can't be here in person. Tonight's topic is a really interesting one, and one that's gotten a lot of discussion, not only here in New Jersey, but across the country. And we're going to examine the FTC's recent final rule regarding restricted covenants. And the second part of our discussion tonight will be a new employed physician services program that we have put together with our corporate partners at Flynn. And this is a recognition that a lot of our membership, the majority of our membership now, is in an employed environment, whether it be with a large group practice or hospital medical staff or otherwise. And these are some of the programs, services, and educational programs that we'll be providing as a membership benefit to our physician members. And with us tonight to present on both the FTC rule and what it looks like and what it might mean for medical practices is Mike Moroney with Flynn and his law partner, Catherine Flynn. They're together going to take us through the next hour or so. We'll make sure we put some time in for questions that you might have. And we're going to get started right away. So with that, I'll turn it over to Mike and let him begin with a little self-introduction and his portion of the program. So take it away, Mike.
All right. Thanks, Larry. And thanks for everyone for joining us tonight. We appreciate it. Thanks to Larry and Josh and all our friends at the MS&J for helping us to pull this together on short notice and get it out to you folks. As Larry mentioned, a new rule was just passed by the FTC, and we just wanted to share with you folks some of our preliminary thoughts as to what this is going to mean for folks in the healthcare sector. As everyone's no doubt heard, on April 23rd, just of this month, the FTC finalized its rule abolishing the vast majority of what they call non-compete clauses across the United States. And that's now referred to as the FTC non-compete rule. It's kind of a misnomer because it means not non-compete. But the effective date of the rule will be 120 days from when the rule is published in the Federal Register. That just happened this Tuesday, May 7th, 2 days ago. So the effective date of the rule will be approximately September 7th, about 120 days from now. Non-compete agreements have historically been a primary feature in employment contracts entered into by physicians and senior executives and clinicians, particularly in the healthcare industry. And these agreements have always been viewed by the employers as critical to maintaining the value of their organization, particularly in the healthcare sector, given the personal relationships that are often developed between the physicians and their patients. The practical effect of that, of course, was always to significantly limit what we'll call employment mobility of the contracted physicians and clinicians, limited where they could go and when they could go. So the FTC's ban on non-compete clauses basically seeks to increase the competition in the marketplace, as well as the mobility of the physicians to move around. The idea being that this will benefit the patient population as a whole and hopefully improve the delivery of healthcare services. Whether they actually achieve that goal remains to be seen. Just real briefly, in January of 2021, the Biden administration issued an executive order looking to promote competition across the country as a whole to improve the economy. Shortly thereafter, the FTC issued both a policy statement addressing the ability of workers to move around in their industry, finding employment, and then announced a plan to ban non-compete clauses altogether. This resulted in a new rule being proposed just about 2 years later in January of 2023, at which time the FTC invited public comment, as they always do. That's not unusual. What was unusual was the amount of comments. It received over 61,000 comments from all quarters, including certain participants who were arguing specifically for a healthcare industry-wide exemption from this proposed rule, a position that unfortunately the FTC rejected. Instead, this past April, on April 8th, the FTC voted only by a 3-2 margin, and we'll talk about that in a moment, but voted 3-2 to publish their final rule banning non-compete clauses and applying it to physicians and other healthcare providers. So that's the new rule. Voted on April 8th, announced 24th, and it'll go into effect roughly September 7th. Now, this rule, for our purposes, has basically three main components. The first, it declares non-compete clauses as an unfair method of competition when negotiating or drafting employment contracts. In other words, employers will no longer be able to force employees to sign these agreements, and they will no longer be able to enforce those clauses against employees. So that's the first thing. The second thing is the rule also requires the employers to notify all the impacted or affected persons under contract immediately and let them know that the non-compete clauses will no longer be enforceable. Now, this is maybe a good spot just to say there is a limited exception to that piece right now, which is for what they call senior executives. The exception simply says that senior executives who currently have a non-compete clause in their current contract are grandfathered in, or actually it's the employer who gets the benefit, is grandfathered in, and that clause will still be enforceable only to the senior executives and only for the remainder of the current contract. Going forward, even the senior executives will be exempted from that kind of a clause. And senior executives are generally referred to as persons who make in excess of $150,000 a year. They actually have a specific number, I think it's $151,464 a year, and who also are in positions to make policy-making decisions for the entire organization. And it has to be the whole broad organization. But even those folks, after their current contracts expire, are going to be immune from these kind of clauses. Now, not surprisingly, as soon as the final rule was announced, a number of groups filed lawsuits challenging it, including the United States Chamber of Commerce. These challenges included both seeking injunctive relief to stay the enforcement of the act right away, and also efforts to vacate the rule in its entirety. It's possible, and it's probable, I would say, that different courts will decide these cases in seemingly inconsistent ways. There's even a good potential that we'll see different results in different parts of the country geographically. It bears noting, we mentioned this a moment ago, that of the 5 commissioners who voted on this, 2 voted against it. It was only a 3-2 vote. And one of the commissioners even went so far as to say she believed this rule may not survive the inevitable legal challenges that are going to come down the pike. So that's where the rule's at. Now, everyone's heard the rule, and everyone's probably also heard and wants to raise their hand and ask the question about whether or not this ban on non-compete clauses applies to nonprofit hospitals. And Catherine's going to do a deep dive on that in just a moment. But just to put it to rest, to tell you now, it does not apply to nonprofit hospitals. However, and this is very important to emphasize, the reason that the new FTC rule banning non-compete clauses does not apply to nonprofit hospitals is simply because the FTC, by its definition as an organization, only addresses, and its rules only reach entities that are, quote, organized to carry on business for profit or its members' profit. In other words, the only reason this ban doesn't apply to nonprofit hospitals is simply because nothing the FTC does applies to nonprofit entities. For lack of a better word, they don't have jurisdiction over nonprofit entities. Nothing they do applies to nonprofit entities. If we read the rule, and you know, Josh and Larry have and Catherine has, if anyone who reads the rule, you'll see there's no mention anywhere in the text of a carve out for nonprofit entities. There's nothing in the rule that says we're not applying it. It's simply silent to that. And the reason is because nothing the FTC does applies to nonprofit entities. There's nothing in there that articulates what we would call a policy-based decision not to apply the ban to nonprofit hospitals. The FTC doesn't discuss the question of whether or not it should be. Rather, the rule simply doesn't apply. And the reason we bring that up is for our purposes, working with employed physicians, there's no basis, that Larry or Catherine or Josh or I can see to suggest that the logic underneath the FTC's rule or the intent of the FTC's rule would not apply to nonprofit hospitals and their physicians. There's no reason it wouldn't. So therefore, we believe it's an area that will be addressed in the courts shortly. And more importantly, for our purposes, it's something that can always be addressed by any of our individual physicians when they're negotiating or renegotiating a current employment contract. Meaning on an individual basis, although this FTC ban does not automatically apply across the board, the arguments advanced by the FTC and the position they've taken would certainly be persuasive when arguing on behalf of any of our individual physicians on a case-by-case basis. At a minimum, it provides physicians with significantly increased leverage going forward when negotiating their contracts. So the rub that we'll see eventually is the new rule. It's well intended to promote competition and freedom of mobility for the physicians, but like everything else in life, it comes at a cost. And specifically, it's going to be the impact on hospitals and clinics and medical groups, because these organizations often rely upon these non-compete clauses to protect what they believe is their investment in the recruiting and training and developing of their talent, so to speak, only to then risk seeing it walk out the door once that investment comes to fruition and everyone's ready to go. So these non-compete clauses historically were never intended to absolutely prevent an outflow of talent or to prevent people from changing jobs. It was simply to restrict it with a certain defined radius to prevent that literal, somebody walking across the street and hanging their shingle out, phenomenon that you used to see. A lot of that doesn't apply in our modern era of so-called nonprofit hospitals that are multi-million businesses. So the arguments are not necessarily going to apply. We had one of the slides real quick. I can just go to what the benefits for these non-compete clauses for the physicians are fairly obvious. It provides increased job mobility. Yeah, this one right there. Thanks, John. The benefits are obvious. Increased job mobility. It's kind of like entering the NCAA portal. You can move around. You're not restricted. You can talk to wherever you want to. You can go wherever you want to. You're not hindered. You're not contractually restricted. The second piece, commensurate that, of course, is a potential for much higher earnings. It's the free marketplace at work. Now that you're unrestricted, he or she can present themselves in the light most favorable. It can negotiate on your behalf. You have more bargaining power because you're unrestricted, so to speak. And those two things together just equal expanded career opportunities for physicians to explore any manner of other opportunities, whether it's to work in a different specialty or a different geographical area or in a different corporate structure. You're basically an unrestricted free agent now because of this ruling. And then, of course, again, there's a flip side to that. The next slide will show some of the concerns. This slide's all the benefits. Now, this white slide, these are the concerns, which are mostly on the employer side. And we've kind of covered most of them already, but the first concern is just this outflow of talent coupled with an increased difficulty in retaining your talent. On the one hand, it's easier for them to leave, and at the same time, it's going to be harder to negotiate with them because they have more leverage. So it's an advantage to the physician, but not so much to the hospital. Same with the outflow of knowledge. There's a concern of proprietary information walking out the door. Now, patient care, this is an argument that's advanced in almost every scenario that we have, a concern for patient care, and it's always effective because it's unassailable. You can't argue against wanting to increase, the quality of patient care. So it's an effective argument, particularly in the more rural areas where you don't have the glut of physicians and hospitals that you're competing against. And again, we talked about the expenditure of resources and a concomitant lack of return, or a concern that you're not going to get a return for the investment in the professional development of your folks. There's a concern for increased health costs. Again, this is the free marketplace of work, but this is the dark side of it. You know, this is the ugly side. Like a lot of things, if the cost of producing a product and getting the product out there goes up, then inevitably those costs work their way back to the consumer, or in this case, the patient or the insurer. So there's a concern that basically hospitals or medical groups are going to have to pay more money to keep their people, you know, and that cost is just going to be passed off like it is in any other situation. And lastly, there's a concern, of course, for increased regulatory work, because again, more regulatory work means more compliance work, means more time taken away from practicing medicine, and, you know, more resources spent on that. So these are the concerns. That's kind of an overview. And now, you know, Catherine will take a deeper dive into some of the specifics of this. And then, you know, if anyone has any questions, we can certainly come back in a couple minutes and address any questions anybody might have. Thanks.
Hi, can we go back to, it was a bright blue slide about profit versus nonprofit? Perfect. Okay, so let's talk a little bit more about nonprofit hospital systems, exempt or not. And like any area of the law, there's a lot of gray involved. There will be a fair number of challenges to this rule. The U.S. Commerce Association has already, immediately upon the rendering of this rule, the publication of it, they filed, U.S. Chamber of Commerce, they filed a lawsuit against this rule because it has very far-reaching implications for all employers all across the country. So for purposes of how it affects physicians, especially in the state of New Jersey, we thought it important to get into the nonprofit hospital systems and whether or not we say exempt, but as Mike had indicated, that they're not subject to the FTC jurisdiction because they're not for profit. However, that gray area that always arises, and there are multiple gray areas involved with this particular legal issue, is what does the nonprofit hospital system look like? And what will the commission, the FTC, look at in determining enforcement? And what is applicable to nonprofit hospital systems and the factors that they look at? So charitable and other 501c3 organizations, like the major hospital systems in New Jersey, including tax-exempt hospitals, are exempt from the rule. However, the commission's position is that exempt organizations may come under its jurisdiction based on profit. So the way they're going to look at this is it's a follow the money kind of proposition. So there's a two-part test, and what we're seeing in New Jersey is you have historically not-for-profit or nonprofit hospital systems. We're seeing an uptick in the for-profit hospital systems, and clearly this rule would apply to the for-profit hospital systems. And what we see on the horizon is a hybrid within one organization of for-profit and nonprofit organizations, or different divisions or affiliates within that system coming together, and really a hybrid situation. So the test that the FTC, in looking to enforce, if there is a for-profit situation, either in a hybrid entity or clearly just for-profit, the rule applies. It gets more difficult when you have, or becomes more difficult when you have that hybrid scenario. And the mere fact that an entity has 501c3, charitable nonprofit status from the IRS, is not the only thing that they're going to look at. So the FTC is going to look at the source and the destination of the income. So the money coming in, what is the source, the revenue, and then where is it going? And the where is it going piece, if it goes to individuals or owners or members of the organization, even if it's a hybrid scenario, not for profit, with for-profit affiliates, if the money is flowing to the not-for-profit entity through their for-profit entities, they may say, and this is where there's going to be a significant legal challenge, they may say that the rule applies. They'll also look at private benefit or private annulment. So what do we mean by that? Private benefit. Hospitals partnering with for-profit entities. So for-profit physician group practices that have an agreement and they're working with, as an affiliate, a non-for-profit hospital or hospital system, they will look at that. Very interestingly, they will be looking at unreasonable compensation. So the whole idea behind a non-profit hospital or health system is that the community derives significant benefit, and that's why they, and they're organized for hospital purposes, that's why they're given that tax-exempt status. But the Federal Trade Commission, one of the things that they've indicated they would look at is the compensation of those high C-suite level executives, along with anyone else who's profiting at a substantial compensation level. They'll take a look at that to determine whether or not that's reasonable. And if it's unreasonable, how much money, following the flow of the money, the destination of the income, how much compensation are these high-level executives making? And really, is it appropriate because there is that private annulment that they can hang their hat on to determine that, wait a minute, even though you may have tax-exempt status through the IRS, you're still under our jurisdiction. That remains to be seen. And physician hospital organizations, they will be taking a look at, again, that's that affiliate kind of scenario. If it's a for-profit practice group affiliated with a nonprofit hospital, they'll take a close look at that. And as I've indicated, the IRS tax-exempt status is not an automatic exemption from the FTC rule. Now, all of these factors that the commission will look at, this is all very new. We don't know what they will finally find, but what we do know is whatever they're ruling or they're finding on whether or not there's FTC jurisdiction, there will be significant legal challenges. So we would anticipate a high level of litigation for many, many of these issues. Next slide, please. So just to put it in visual context here. So we have approximately 80, and this is as of 2022, I believe, 80 acute care hospitals. Nonprofit, we have about 63, for-profit about 15, and 3 or 4 government. So with respect to government facilities, government hospitals, state-owned or run hospitals, that would fall, because it's not considered nonprofit, that would fall within the Federal Trade Commission's jurisdiction. But in looking at the number of nonprofit versus for-profit facilities in the state of New Jersey, that leads to our next slide. And that's the, I'm sorry, can we go to one more slide and we'll come back to this? The practical implications for New Jersey employed physicians. So the good news is, if a physician is employed by a hospital system, one would think that they would be not covered by or they would benefit from the ban, and no non-compete provisions in contracts moving forward, and enforcing them from the date it's published and effective on. But that's not the case. If it's a nonprofit hospital, the nonprofit facilities are going to say it doesn't apply to us, so we can still go ahead with non-compete provisions in our agreements. And for-profit hospitals, there's room for negotiation. Government hospitals, there's room for negotiation. So as it stands right now, there are roadblocks and obstacles for employed physicians with nonprofit entities. The practical implications for employed physicians, contract negotiations, initial and renewals, even though there may be, the hospitals may take, or the system may take the position, doesn't apply to us, so we can include a non-compete. There may be room for negotiation on that because it's subject to challenge based on the other factors we've discussed, like these hybrid entities. And the larger hospital systems have a lot of that hybrid for-profit entity component that there's leverage to negotiate that. When looking at entering into an agreement or renewing agreements, you want to look at the term of the contract and how many years are you going to lock yourself into an agreement. And if it contains a non-compete, that is something that we'll talk about and what that should look like and what the state of New Jersey law is on non-compete agreements. You always want to look at and review the reasonableness of a non-compete clause. You want to ensure that the agreement is memorialized. We recently had a client who has some very stringent provisions that the doctor is being held to, and there's just a one-paragraph letter memorializing some of it. So he's in good shape because he wants out of that agreement. But for purposes of making sure that there is no ambiguity about what you've agreed to, you always want to make sure that it's memorialized in appropriate language. It's also important to ascertain the organizational structure of your employer, nonprofit, for-profit, or hybrid, or both. Because if it's for-profit or a hybrid of both, you may be able to negotiate not having a non-compete in your agreement. If it's for-profit, there's a different way to go about doing that, but the likelihood is they'll dig their heels in and say, no, we need that non-compete. Can we go back to the prior slide? Thank you. Okay, so the status of New Jersey law on non-compete agreements. Before we get into these specifics, it's important to know that the FTC's position is that their rule trumps, it preempts state law, rules, and regulations. Now, in New Jersey, there is no statute or regulation governing non-compete provisions in an agreement. However, there is case law, and the seminal case is Carlin versus Weinberg. And the court there found that non-competes involving the practice of medicine by physicians is permissible under certain circumstances. However, it's prohibited for behavioral health physician-patient relationships or therapist, psychologist. You can't, it's contrary to public policy. So what have the courts found they rely on in determining whether a non-compete should be upheld or if it should be found to be nullified? So the reasonableness. Non-compete agreements must be reasonable in scope, what the practice involves, duration, how long that non-compete is in place once employment is terminated, and geographic limits. The courts have found duration anywhere from 6 months to 2 years, and it's very fact specific depending on the practice or the specialty that the physician's involved in. Geographic limits, it depends on where the physician has been practicing with the particular employer and where the physician intends to take that practice or his practice or her practice when they finish their employment with their current employer. Depending if it's a rural area, the courts will look at it one way. If it's a very dense urban area, they look at it differently. Legitimate interest. The agreement, the non-compete clause, should protect the legitimate interest of the employer, trade secrets, or confidential information. Where that gets dicey is when you have the physician-patient relationship interjected into the analysis. And because a physician is seeing a patient at a particular healthcare facility and develops that rapport, that, a non-compete would basically say, you can't take this patient with you somewhere else because we're not going to let you go work somewhere else in the catchment area that that patient resides or is currently located. The flip side of that is, what about the patient-physician relationship, which is a very, very important relationship and shouldn't be interfered with because of a non-compete clause in a contract. So the courts will look at the legitimate interest of both sides of that equation. No undue hardship. Agreement should not impose an undue hardship or be contrary to public interest. And the public interest is that physician-patient relationship and the patient's freedom of choosing where they want to be treated and by whom. Enforceability of the provision, the non-compete provision, it can't depend on the manner of separation from employment. Courts will consider circumstances surrounding separation, but it can't depend on the manner. If there's a bad faith situation or some kind of nefarious circumstance that warrants the physician being terminated, the courts will consider that. But if it's merely the end of the contract term and the physician wants to move on to another employer, that's something the courts will consider and won't be viewed so negatively on the part of the physician. If a doctor has a license suspension for a certain number of months and hasn't been able to provide patient care, that's one of those circumstances that if ultimately the physician is terminated, they'll take a look at that in determining the enforceability of the provision. I mentioned previously the duration. There's no specific duration by law, but 6 months to 2 years has been upheld as being reasonable. Beyond 2 years, they take a very close look at whether or not keeping someone from practicing in a certain area, whether or not that's appropriate. Okay, we can go 2 slides ahead. Okay. Now, impact on medical practices. In as much as we've talked about whether or not non-compete agreements for employed physicians will be upheld and what the new rule means for employed physicians. For physicians who own or run their own medical practices, there's a different impact. So let's take a look at a few elements here. Non-competes, I think that was a typo. Non-competes for an in-office setting, no longer valid as of August, September, when the rule kicks in of 2024. So if there are non-competes with an employed physician, no ownership, an associate that is brought in and has a contract, non-competes are going to be a problem because the rule will apply. If there are employees that currently work for a medical practice and they have an agreement, a written agreement with a non-compete provision, this rule requires that those employees be put on notice. Contained within the rule, it's section 901. The FTC has included model language for the notice, and the notice has to be served on any employee that has a non-compete currently in their agreement. And so it's basically pulling up that model language and providing it to all employees who have a non-compete currently existing. Moving forward, no non-compete can be contained. There should be no non-competes contained in an employment agreement with anyone subject to a contract of employment where the terms are memorialized. Recruitment and retention. This probably gives leverage to those looking to become employed, so potential or prospective employees. for the practices looking to employ individuals that ordinarily you enter into a contract with that usually have non-competes, can't do it anymore, and that gives them a bit of an upper hand. What you can consider, however, is non-disclosures, non-solicitation provisions. However, the courts in New Jersey will look at those. Now, non-disclosure, non-solicitation, and non-hire clauses need to be narrow, but they're not subject to this FTC rule. However, to pass legal muster, they have to be narrow and reasonable to protect a legitimate business interest. So it has to be to protect the practice and narrow, not overly broad, in order for it to be upheld legally. Okay, we can move on. Okay, so the implementation process. This is just bullet points, with respect to what's involved in moving forward if you're in an office scenario. You have to review existing contracts to see if they have the provisions, the non-compete provision, and then make the determination, who do we have to put on notice? If we don't, then just document that you don't have to put somebody on notice so that you're protected if somebody comes to look at that in some way, shape, or form. Consulting a legal team, if you have any questions or concerns, again, this is all very new. It's all very gray with respect to applicability. It can be very confusing. What applies, what doesn't, what do we need to do? Not a bad idea to consult a legal team if you choose to do that. Drafting updated contracts. Got to take a look at the contracts, make sure that they're complying with New Jersey requirements, as well as the FTC requirements if that contract applies to an employee that falls under the jurisdiction of the FTC. Communicating with the employees, you can look to the rule, and it's 901, and the model language is there, exactly what you need to put in the notice. You just put it on your system as a template and then provide it to all employees that it applies to. And then taking a look at the contracts moving forward, you have to implement the changes. Lastly, it's important to continuously monitor any updates or changes to the FTC's final rule and adapt your employment contracts and policies. Policies are important. To make sure you're in compliance. And we do know that moving forward, the FTC's rule and its applicability and the challenges, this is going to be up in the air for quite some time. Constitutional challenges, state law challenges, employer-employee challenges. There's going to be a lot of litigation involved in this. So as it rolls out, we all have to keep up with what's required. It applies to law firms, by the way. So we're going to be dealing with that as well. Next slide. Okay, Mike, I think that's yours.
Yeah, and thanks, Catherine. This is really just kind of the last two slides are just summaries of what we already talked about. We didn't really get into the antitrust aspect. I suspect the audience tonight's not particularly interested in the antitrust minutia of the non-compete clauses, but we just have it here because it's going to be challenged. And of course, any challenge from any interest group, if successful, to vacate or stay or undermine the rule is a benefit to anyone looking to challenge the rule. Professional associations, of course, those are going to be, the medical societies and groups and hospitals and on both sides of the aisle, depending how the first few decisions come down from the courts that we'll probably start seeing in just a couple of weeks. And battles between the states, because I think Catherine and I both touch on this briefly. The delivery of healthcare services varies greatly throughout the country, geographically, I'm trying to say. So there's going to be a lot of challenges between individual states, and where New Jersey comes out on that, will remain to be seen. Obviously, we're one of the more generously populated states in terms of healthcare providers, and available facilities, but still, like it's whatever happens is going to apply to all. The next slide really is kind of the summary of how this is all going to shake out. It's sort of an upside down pyramid of where the benefits, where the biggest impact is going to come from. Certainly, the biggest impact is going to be on the increased ability of people to move around in the workplace and job opportunities, the freedom of movement. That's by far going to be the biggest impact of this rule if it stands in its current form or anything close to its current form. And that's followed closely by eliminating a lot of geographic barriers. That goes hand in hand with the first one. They go together. It's again that freedom of movement. And as we discussed, that's going to lead to increased wages and earning potential. The idea of free agency, and you can see on down the list. I mean, all those things are going to be results, we think, of this rule in sort of descending level of impact, I guess, if you want to say. The fifth one there is interesting. They talk about industry consolidation or closures. Again, I don't know if that's going to impact equally across the country, for obvious reasons. And we could have a whole nother seminar on whether that's a good thing or a bad thing. We could leave it to the folks at the MSNJ to lead a discussion on that. But and then heightened competition, of course, that really goes hand in hand with the potential for wage growth. That's a downside to the hospitals. Or either way, the hospitals are going to pay more to keep this talent, to get the talent, or to prevent them from moving around. It's going to cost the employers no matter what. But that's kind of an upside down bucket of where we think the impact's going to be felt, at least initially, unless or until the rule is revised.
Okay, so future outlook, the tip of the night is when you're negotiating an employment agreement or renegotiating your employment agreement to continue employment with your current employer, know that you can negotiate with respect to a non-compete if they insist on including that. And the best thing you can do is limit the number of months or years, the less time and the fewer miles. So geographically, you want that circle to be small with respect to how far from your current employer they're saying you can't work, and the time. The less time for you that non-compete is in place, the better it is. So less time, less miles. That's the helpful legal tip for tonight.
Well, thanks, Mike and
Sure.
Catherine. Josh, maybe we could stop the share for a moment and just see if there are any questions. I'll ask you to just use the hand raise if you do have a question. And I just want to start with one. Great presentation, by the way. I learned a lot. I didn't hear any mention of specific penalties within the rule for violators. I'm assuming that it would be the typical engaging in antitrust behavior, and then therefore the penalties would be kind of consistent with whether you were engaging in boycotting or dividing markets or any other anti-competitive behavior. Is that what they're contemplating in terms of a penalty structure if employers should violate the rule, assuming it's implemented in its current form?
Yeah, I think a little bit of what we've seen so far suggests that it will be handled along the lines of most FTC complaints, which is to say, if the FTC receives a complaint from a facility that this has happened, the FTC initially doesn't have the authority to levy a fine or a penalty or create any kind of consequence. Instead, what they do is they issue what's called a cease and desist letter, putting that entity on notice that you can't do what they're doing. And then if it continues, then they can penalize them for violating the cease and desist order. So it's sort of it's kind of like trespass. If you think you can't be trespassed immediately, you have to be warned. But once you have the warning, then you can be trespassed. It's same kind of thing. Like the FTC, upon the first violation, will issue the cease and desist notice, and then if that's violated, that's what they hang you up on. If that makes sense.
Great. And just one other question. I believe this will be held up for weeks, months, maybe even years, over questions whether the commission actually had the authority to do what they're doing. What's your view on that in terms of the physicians on the call and listening in to this recorded message? How it's not going to happen tomorrow, might not happen in a year, but what are we looking at in terms of monitoring, do you think?
So there's it's what we refer to as the major questions doctrine. And that is a significant challenge that applies overall outright to the entire rule, applicability anywhere. And that is whether or not the FTC had the authority to issue this ruling when it has such significant policy ramifications. And the argument there is by those challenging it is that only Congress can do that. So that's a big argument. That's something that will put this in a holding pattern for quite some time. So it's quite confusing with respect to how to proceed. But that's the biggest legal challenge, meaning far-reaching and significant with applicability across the board to all employers, all employees.
Thanks. Well, I don't. Oh, I see one. Oh, Josh has his hand up. Go ahead, Josh.
I do. Thank you. So if you could correct me if I'm wrong, but it sounds like the analysis with regard to for-profit and not-for-profit entities is that, and this is probably an overgeneralization and subject to challenge, but generally for-profit entities will be covered by the FTC rule, but not-for-profit entities, especially where there's no question that they're operating in a not-for-profit capacity, that entity will be covered by presumably the original New Jersey law on this, the Carlin versus Weinberg factors.
Correct.
All right.
Correct.
Cool. And then actually, I do have one additional question concerning, I don't even know, honestly, if they're considered non-compete clauses, although they would be considered restrictive covenants. Can you shed any light on provisions that exist in some employment contracts that don't say, or rather, instead of saying after termination, you can't work in XYZ location for ABC amount of time. Instead, they say during the term of employment, you are restricted from working in any other capacity for another employer. Do you know the application of the FTC rule to that type of provision in an employment contract?
Yes, the answer is it will not apply. The FTC ban only applies to post-employment when you've terminated your current position, when you've left your current position. It does not ban an employer from having that kind of a clause in place for a current employee based so that not allowing them to work both sides of the street at the same time. The employers are allowed to prohibit that. The FTC ban only has its genesis after the contracted person leaves that position. It's post-employment for now.
Thanks for that. Well, I
Yeah.
do want to be able to get everybody done here in 1 hour. We promise it's only 1 hour of your time. So I'm going to, one of the things that we've done at MSNJ, kind of looking at the vast majority of our members that are now working in an employed setting, either a W-2 employee and working for a hospital or hospital system, it becomes a much different dynamic in terms of the kinds of services that the medical society has historically provided to its physician members. And so when we looked at that, if you're working at a hospital and you have a dispute with your employer, there's not many people that are coming to your rescue or to your assistance. And so what we've done with Flynn Watts is put together a program that has some member benefits just through your membership with MSNJ, and then the ability to enhance those benefits if you feel you're in a position that you need that. So I'm going to ask Catherine and or Mike, who's ever given this part of the presentation. It's a couple of slides, just kind of what the MSNJ benefit looks like, and how you access it, and what you get with your membership in terms of value. So let's go to that really quickly now. And again, we'll try to save a minute or two for questions at the end. So go ahead.
Okay. So let's talk briefly. We can get to the first slide. Oops, there we go. Thank you. So Flynn Watts, we're a boutique healthcare law firm. And we started about 6 months before the pandemic hit. We can go to the next slide. And we received, and it was a strange phenomenon. We started, because we work remotely and we were set up for that. We started receiving a lot of phone calls and outreach through email online from physicians who were employed with various questions. And we found that almost to a physician, it was difficult for them to find some legal advice without signing retainer agreements and doing the search and interviewing and all that cumbersome stuff on the front end, when there were questions that could be answered pretty quickly on a number of different issues. So what we decided at Flynn Watts was, how can we address this need? And this would be a good thing for doctors to have what we are calling the Healthcare Provider Protection Plan, where it's a subscription service where there's priority access to this legal program. And it's a curated menu of legal services that come up and need to be addressed quickly without the process of hiring and retaining and getting somebody to call you back, for an annual subscription fee that is very reasonable and cost effective. So the issues, we decided these are the issues that we were getting most of the calls about and we think would be most beneficial to physicians. So it's investigation support, fraud and abuse, Department of Justice comes in. If there's a Board of Medical Examiners investigation, we jump in and give you advice on what your next step should be. Employment contract review, which is key to what we are partnering with the MSNJ about, and I'll talk about that in just a minute or two. But the initial employment contract review to make sure that what should be in that contract is there and what shouldn't be there is taken out or negotiated. Subpoena response, HIPAA compliance review. If the OCR gets in touch or the state and says, hey, there's a HIPAA violation, reach out to us, and our access is immediate. Malpractice litigation support. We have been involved in malpractice defense for close to 40 years, I hate to admit it. And it's that support that you need that you don't always get from defense counsel because they're focused on defending. It's the personal counsel piece of it, insurance coverage, what the process is about. And that's something, what you do when you get served with a summons and complaint, we tell you immediately what to do. We're a phone call away. And impaired practitioner advice. We had many doctors contact us during the pandemic about this particular issue. It also includes educational and practice-related resources, updates on hot topics, alerts, newsletters, webinars, and discounted rates for legal services if it goes beyond this menu of services. So we developed that program, and then we moved to the next slide. And in conversation with Larry Downs about what this program is, he said, well, what is this about? And we had a number of conversations, and it made sense for both the MSNJ and for us to partner because we're corporate partners and to provide a free benefit. We're calling it HP free, which is exclusive just to MSNJ members. And those benefits include contract review of initial or renewal physician employment agreements by the attorneys with our firm through HP3. And we'll provide an issue spotting report card. And again, we've looked at the agreement. This should be out, this should be in, this is where you can negotiate, or if there are any questions on that, we engage and we will answer whatever questions the MSNJ member has. We've also put together an employed physician resource library. And speaking with Larry, we addressed the needs, the burgeoning needs of employed physicians, because many physicians are now employed by hospitals or hospital systems, or practice groups, and issues come up. Certain issues you might not be comfortable in speaking with the employer. This provides some benefits to the MSNJ members, and it's for all members, dealing with employed issues, employed physician issues. So newsletters, alerts, articles, videos like this, because it'll be on the MSNJ website, will be provided through the MSNJ. And if there comes a point in time where more is needed by one of the MSNJ physicians, we will do that work at a discounted rate because of that physician's affiliation with the MSNJ. We think this is a very good way to go in helping physicians without the cumbersomeness of having to go through that process. But it's also just being a member of the MSNJ provides you with some free legal consulting and resources that we think would be very helpful. Now, the way to get to, if you're interested in HP3, it's to go to the Flynn Watts website, which is on the face page of these slides. And for the MSNJ members, if you're already a member, just contact the MSNJ. They will provide you with a link that will push you right to an exclusive portal on our website just for MSNJ members, where you just have to sign up and you're in and you can access these exclusive benefits.
Thanks, Catherine. Thanks, Mike. We do have a minute or two. If there's a burning question, just use the hand raise function. If there's not, I'll give you a couple of minutes back of your evening, but thanks for joining us today. And for our second installment of the MSNJ seminar series, we're planning our next one. I believe it's going to be, we'll do one in June. We'll probably take July and August off. We'll give you all a beach vacation and then start up again in September. So thanks for joining us, and have a good night, everyone.
Thank you all.
Thank you for having us, Larry.
Have a nice evening.
Thank you.
Thanks all.